Hello friends. Today I am here to learn you about some penal laws, basically the Indian Penal Code, which has been enumerated in 1860. Basically, the Indian Penal Code brought by the Britishers in India because at the time of enumeration of the Indian Penal Code at 1860, the Britishers rule was there. So the Britishers basically works on the basis of the Latin terminology, and every penal provisions and every penal laws of any country basically works in two different categories. One is actus reus, second is mens rea. So our Indian Penal Code 1860 is also have the same basis of criminal intention and the act, and our Indian Penal Code basically works behind a Latin terminology, that is actus reus facit reum nisi mens rea. That means there is no act without guilty mind. What does it explain? It explains like every act done without a guilty mind is no crime. That means it is highly tightened up to the strict liability. One has to prove the intention, to prove the guilt of any person. And what is the difference between intention and the motive? There are one more. If we put one step further, then we came to know that the motive is also the very important ingredient of the criminology. And now we must learn about the difference between the intention and the motive. Intention is what, in which manner one person has killed, one person has committed any act, that is called intention. Like I will illustrate an example before you. Like A has a stick in his hand. If A has a stick in his hand, if A tries to put that stick on that person's head, that means he has the intention to kill that person. If A hit by that stick on the shoulder of that person, that means he has no intention to kill that person. So that is what I want to explain you right here, that the intention of any person can be gathered only by the manner of doing any act, how, in which manner, in how he acted, and what is the different things which what is the thing which separated the intention from the motive is motive, what ulterior purposes, for what purposes he has done that act. That is the basic difference between the intention and the motive. And now I would like to come I would like to refer you some few sections from few laws of the IPC, which makes the differences between the intention and what is the actus reus, what is the mens rea. So I would like to refer you some sections. Like first of all, I would like to refer here section 378, which defines the theft. If one person, first of all, the basic ingredient of the theft is the property must be movable. Theft will not be applicable on the immovable properties. So first of all, there must be a movable property, and one person moves that property without that person's consent, out of that person's possession, but dishonestly. What is the actus reus and what is the mens rea in this case? Actus reus, as and when he has moved that article which he has intended to stolen, that means he has done his actus reus. And if he has done so dishonestly, that is mens rea, that shows his guilty mind. Suppose we have moved one article from one room to another room at our own house, then that is not dishonestly. We have moved the article simultaneously, but we have no guilty intention, we have not dishonestly, we have not intended to stolen that property. So this is not theft. That is what I want to explain you. There is no crime without guilty mind. If you have no dishonest intention, then you always keep moving the articles from one room to another room at your home. You have taken your spoon in your kitchen, and you have eaten from that spoon, and you have kept the bag. That is, you have moved the spoon. But this is not guilty. This is because you are not having a dishonest intention. Suppose if I am talking, if one person can say this is your own house, this is your own thing, so how can it be possible that would be theft, that would amount to theft? If you go to some other person or your friend's house, if you go to your friend's house, you will take a water bottle without his permission. Without his permission, you can take the water bottle to drink some water, and that is not dishonestly. You have not taken that water from dishonestly. Though that is not that will not fall under the under the provisions of the theft, because the intention is the most important ingredients of the penal code. So I would like to say you, I would like to, why I am explaining that to you, because these are the basic feature of the Indian Penal Code. Even not Indian Penal Code, this is the basic feature of the criminology. Not even India, even throughout the entire world, the provisions of the penal provision can only be governed by those two basic structures, actus reus and the mens rea. Actus reus, once you have moved the article, and the mens rea is what your guilty mind, what your mind says that. If your mind says that I will take that, if you suppose I have this ring, if you have stolen that ring, you have not stolen yet, but you have kept this ring to some to such a place that no one can see, and later on I can take that out from that possession. That also that will also fall under the under the provisions of the penal theft, because you have taken that article dishonestly. Now I would like to refer you some examples like where there is no mens rea, but they are still punishable. Now I would like to refer you section 304A of IPC, which enumerates the rash and negligent act of any person which caused death. Suppose you were driving a car, accidentally some person came in front of your car in the line of your action. Your car is acting on that way, and that person came in the line of your action accidentally, not intentionally, but you just hit that person and that person goes die. Then that person dies because of your accident, your hit, we came in your line of action. You did not intended to kill him, he just came in the line of action, but simultaneously you have committed some person death. The strict liability may not be there of the murder, but simultaneously you must be held liable, because mens rea is the basic ingredient of the IPC, but not in every cases. Some cases has been exonerated from the requirement of the mens rea, but in this case, as I have gathered from the circumstances and I have gathered from the basic books and the textbooks and the many other things, and I have applied my mind, then I came to know that it also has the mens rea, the recklessness. What is recklessness? If one person drives a car on speed of 180 on a very rush area, then he knows that he may have hit some person. Because if you are driving the car on 180, on the speed of 180 on the very crowded area, then the probability is always there that you may have hit some person. So that recklessness is mens rea in this case. So this may not be a direct mens rea, but the circumstances can be taken from that mens rea, that the recklessness were there. Simultaneously, section 304A applicable for the accident cases as well as the negligent cases also, like medical negligence. There is a star judgment on their Jacob Matthews case, Jacob Matthews versus State of Punjab, in which Supreme Court held that the recklessness of the doctors were there. That is why they have held that those doctors to be liable. So recklessness is not direct mens rea, but still it applies somewhere to the it hits somewhere to the mind of that person who is doing that act, that he must be acted in a manner as a person of a prudent mind must act. So that is what I would like to explain you on the basis of actus reus and mens rea. That is the introductory part of the Indian Penal Code. Later on, I will keep posting my updates and keep you informing about the rest of my videos and rest of the penal codes. So thank you everyone for watching this video.